So we now start with our panel discussion number 5, which discuss corporate litigation, regulatory compliance and risk mitigation. And to kickstart today's discussions, our first panel dives into the corporate litigation, focusing on regulatory compliance risk mitigation strategies. We will welcome our moderator, Mr. Mohamed Swealam of consultant Andersen Bahrain. Would you like to go on the stage now? Okay, and our distinguished panelists are Mousa Albahrani, Regional HQ General Manager of Future Pipe Industries from Saudi. Ms. Urmila Zacharia, Legal Affairs and Advisor of Namal and VKL Group in Bahrain. Betania Allo, Founder and Principal Consultant of Betania Allo Cyber Law and Policy. And Bashayer Alnaqeeb, Attorney Legal Consultant Bahrain. Let's begin our session. Over to you.
Good morning, everybody. I think that you know me from yesterday, but I'll introduce myself again. I'm Mohamed Swealam, Legal Consultant, Andersen Bahrain. And I'm honored to be moderating this session today. Today's first session on corporate litigation and the crucial areas of regulatory compliance and risk mitigation. As we know, corporate litigation isn't just about winning cases. It's about anticipating, managing, and unlimitedly avoiding risks and in increasing complex regulatory environment. With regulations evolving at a rapid pace, corporate legal teams must be more proactive than ever in staying ahead of potential compliance challenges, whether it's navigating global regulatory frameworks, managing internal controls, or ensuring adherence to industry-specific standards. The risks are significant, and so are the stakes. But beyond compliance, corporate litigation also involves strategy. How do we mitigate risks while simultaneously positioning our companies for success in the face of legal challenges? What's the balance between aggressive defense and practical preventive measures? Today, we will delve into these critical questions with insights from our panel of distinguished speakers who have first-hand experience in managing corporate litigation at the highest levels. We will explore best practices for regulatory compliance, strategic for risk mitigation, and how legal teams can work productively to reduce exposure or to costly litigation. And there is an ancient Arabic saying, which is, most fires start from a tiny spark. So we will start with Ms. Bashayer. She is a Bahraini lawyer and she has experience in this field. Please.
Test. Good morning, everyone. It's such a pleasure to be here with you today, especially that we're here in Bahrain, my hometown. I would like to thank the organizers for putting this summit together and inviting me to speak on this topic that's not just relevant, but I think it's absolutely central to the future of business and the law. So, corporate litigation, regulatory compliance, and risk mitigation. Well, at first glance, you might look at those topics as 3 separate topics, but in reality, they're deeply connected. And understanding how they work together, I think, is key to helping companies stay strong, legal, and of course, protected. Now, what's changing in the corporate litigation? Let's start with litigation itself. Companies used to think of litigation as something that happens after a problem. But in reality, a dispute shows up, you call your lawyer, and the fight happens. But that approach doesn't work anymore, not in today's world. With this fast-moving information, things are moving faster, information is spreading instantly, and one legal case can damage a company's reputation and even its ability to keep operating. We're seeing a shift. Litigation is becoming less reactive and more strategic. It's no longer just about winning a case, it's about maintaining and managing risks and relationships. More than ever, I think companies need to anticipate legal risk, reputation, and relationships. And that's, I think, where compliance and risk mitigation comes into play. Now, let's talk about regular compliance. Most people, when they think about compliance, they think about audits. They think about checklists. Well, of course, they are part of it. However, when it's done right, I think it's more than that. It's about understanding the spirit behind the rules, not just the words. For example, when a company puts in a compliance program, they're not just protecting themselves from fines, they're building trust between investors, customers, regulators, and even employees. And that trust helps the company protect itself from future problems or issues or disputes. In my work with companies in the region, I've seen how good compliance practices have actually prevented lawsuits. I've seen companies catch contract issues early because of a simple internal review. I've seen HR policies that actually stop employment dispute before they even reach the courtroom. Compliance basically helps you spot the problem early. And your chances of avoiding a full-blown litigations are much higher. Now, let's bring the third part of the triangle, risk mitigation. Risk mitigation is about asking a very simple question. What could go wrong and what can we do about it now? Sometimes it means putting up simpler language into the contract. Sometimes it's about training your employees, handling sensitive issues. And other times it could mean that you need to set up internal systems like whistleblower channels or regular compliance audits. That lets the business catch the red flags early before they even become real-life crises. One example, I worked with a construction case where it could have easily turned into a very expensive arbitration. But because the contracts were very clear and both parties had very strong internal records, we were able to settle this through negotiation very quickly and with minimal damage to the relationship. So I believe that's the power of preparation and what risk mitigation looks like in action. Now, we've talked about corporate litigation, compliance, and risk mitigation. We talked about them individually, separately, like as individual pieces, but the real work, I believe it happens when we connect them together. Now, here's how I explain it to clients. Compliance is your day-to-day protection. Regular or risk mitigation is your early warning system, and litigation strategy is your last line of defense. If you treat them separately, you're constantly reacting. But when you connect them, you build a stronger and a smarter legal foundation. You move from being defensive to being proactive. You're not just avoiding a legal problem, you're leading with confidence, knowing whatever is going to come your way. And in today's world, with tighter regulations, cross-border operations, and the rising expectation of the stakeholders, it's not just optional, I believe it's necessary. Now, let's zoom out a little bit and look at the bigger picture, especially here in the GCC. As we've discussed in yesterday's topics, that we're seeing a rapid reform in many parts in the region. Bahrain, the UAE, Saudi Arabia. They're all updating and adding new commercial laws, setting up new courts, and encouraging alternative dispute resolutions. Regulators are becoming more serious. Board of directors are being held accountable in many different ways. But don't get me wrong, this is good. It raises the standards, it makes the market stronger, but it also means companies need to keep up. They need to integrate legal risk into their strategic thinking. Lawyers, consultants, and executives must work together, not only after something goes wrong, but before it even has a chance to. Now, To wrap up, I would like to leave you with this. Corporate litigation isn't your legal problem, isn't just a legal problem. Compliance isn't just a policy checklist, and risk mitigation isn't just a safety net. Together, they form a system that protects your business, strengthens your reputation, and helps you grow with confidence, whether you're advising clients or leading a legal team or running a business. The goal is the same. Don't just prepare for the best, but build for the don't just prepare for the worst, but build for the best. Thank you, and I look forward to hearing your questions and learning from today's panel.
Please pass it to Mr. Mousa. Thank you.
Hello.
Go ahead, Mr. Mousa. Please introduce yourself.
Good morning. Mousa Albahrani. I'm the RTQ General Manager, Future Pipe, for the GCC and MENA, and also have 20 years of experience related to finance, credit control, open order to cash, and recently 2 years back I was the lead in establishment of the RTQ and Future Pipe. By the way, I think I'm the only one who's not lawyer here. If there is someone who's not lawyer, just raise your hand. I need somebody to help me.
Non-lawyers, please. Non-lawyers. All are lawyers. Thank
All
you.
are lawyers.
You are the only one.
Oh, I'm the only. No, there is one.
There is one.
I'm not the only
okay.
one at the end.
2, 3. Oh my God. Good.
Very good. Okay. From my experience here, I started with working with healthcare, with IT, HP, or Nokia Siemens, and telecommunication, FMCG, Mondelez Kraft Food, Buba Insurance, currently in manufacturing. I would try to bring the perspective of business practice rather than are more expert than me in litigation and legal, but I will related to the business and also related to area I was studying the operational risk management. So what my friend said here clearly, we have to focus on cost avoidance rather than taking the cost inherited. So what does it mean inside a from my perspective? We have to have the right governance inside the company where we divide the layers of risk owners and risk control and risk audit. And some people might have some ambiguity and combination of just more explanation to the area where who are the compliance, or who are the auditor, and who are the risk owners. Usually the risk owners, and this is the practice, are the function level people who carried on the risk. And this area, what compliance need to do, and in some companies, I would give an example, they are either standalone, reported to the executive, or they are, in some bank companies, they are related to the legal department, or they are under finance. I prefer to have standalone because it's a combination. No one can have it separately. So the risk owner are the function, and they have this risk and control scenario analysis, self-assessment, and the compliance under the executive. They will help them to identify the risk, the key risk indicator and key control indicator. What we are trying to establish here is the risk of litigation will come from 4 areas. Either we have it from the people, or from the policy, or from the system, or external factors. External factors might have regulation, or some with our supplier or with our client. Things that we control are internally, things that we cannot control are externally. So we have to embed a strategy from the start of the company, from scratch, where we embedded the culture of monitoring and reading our history of loss event, and at the same time we do our scenarios. So we will be proactive. How to be proactive? To spend more and invest more in this area so you are ready for the changes that you will have. We have seen it now with the tariff, we have seen it with COVID. So those people, those companies who are having and embedded in those scenarios in their companies, were easy for them to move to remote working. Others who are not and taken into consideration this area struggle to embed it, and they lost a lot. An example here of the compliance, yes, it's not a checklist, where we have the other parties. So we have the owners, then we have the compliance, then we have the internal audit. The internal audit will report to the board, and they are doing the test. So compliance are supporting, controlling, doing their internal review. Audit are doing the test over the executive, the compliance and the function. This will allow us to have a governance over the 3 layers of control, risk mitigation. So we are more proactive, and we will not wait for the risk that comes from reputation, come from financial, come from any other external factors that we are not ready for. Example from my area, let's say it from Future Pipe, where I started in 2015, the compliance impact. Once you don't have internal KYC, you don't have internal risk assessment or creditworthiness, once I bring the file and I go to you as our partner and tell you, look, I have a debt to be collected, I have case to be opened, the first question you will ask me, did you follow the right compliance and KYC and risk assessment and documentation and signatories? And you have the file, then I'll say, oh. So lesson learned. Whatever you do today, and I always tell it to my team and always when I can negotiate with my client, you are good to me today, but tomorrow I don't know what will happen. External factor might affect you, might affect me, so I need to have my file, my contract, my documentation fully up to date to go to the court. And on each region it will be different. The regulation for me, in case I use it different, I go to UAE and I implement different. Example, for case A, not allowed BDC, and UAE you can use BDC. When I worked in U.S. companies, it's for manufacturing or other companies, non-financing, there is no strict compliance related to AML or YC, while in different countries it will be different. So those different perspectives will give us a sign where we can improve, control, be on top of it. And this is what we need to do to avoid any scenarios. We have to be ready, we have to be organized, we have to focus in improving our system, improving our culture of people, improving our policy and documentation to be realistic, and building this scenario analysis of loss event that might happen and the probability of having what we should do. So crisis functions are part of risk mitigation that should be there in each multi or big companies, because those things are not extremely far from being happening.
It's okay, you give a speech as a professional lawyer. So from that part, I would like you to pass to Ms. Urmila. Please. She's the legal advisor and she's compliance manager in big company. Please go ahead.
Good morning, everyone. I am Urmila Zacharia. I am a corporate lawyer. I'm working at VKL and Namal Holdings, and there I am holding a position of legal head, and I am also looking forward looking at the compliance. So today we got the topic of corporate litigation, regulatory compliance, and risk management, whereas in my company, we always strive to look at the compliance, whether it is that has been complied in a proper way, all the other things have been complied in a proper way. So in today's world, particularly in the Kingdom of Bahrain, the role of corporate litigation and its compliance is rapidly evolving. So in today's session, I'll be talking about 5 main points under the corporate litigation and the risk mitigation, corporate litigation and the regulatory compliance. So first I'll be dealing with the brief description about the corporate litigation and compliance, thereafter the regulatory authorities and some common areas of corporate litigation, and how we'll mitigate the risk in the companies, and finally the role of ADR in corporate litigation. So coming to the brief introduction about the corporate litigation, it says that corporate litigation refers to legal disputes arising out of commercial and corporate activities. So in company, if you see, we have so many legal issues. So just to know, we have this kind of issues, and we need to mitigate against them. So there will be, mainly in commercial activities, there will be so many issues with regards to the contracts, especially breach of contracts, which simply means violation in the terms and conditions between two parties who are executing the contracts, and employment issues, tax violation, etc., etc. So in compliance, it ensures the businesses operates that the legal framework reducing the risk of legal sanctions. So in the present scenario, the corporate litigation has been strongly advocated by the ongoing Bahrain Economic Vision 2030. So it has three main features. First one is sustainability, fairness, and competitiveness. So in Bahrain Economic Vision 2030, it simply says that we are transforming our country, Bahrain, to a sustainable and much reliable country, not with the reliance of oil. Coming to the main regulatory authorities of Bahrain. So first one, as we all know, is the Ministry of Industry and Commerce. So in Ministry of Industry and Commerce, we are seeing that the main operations of ministry is that they oversees the corporate governance, commercial registration, bankruptcy, etc. The second one is the CBB, which is known as the Central Bank of Bahrain. It regulates the banks, insurance companies, and it enforces the action includes license suspensions, fines, or criminal actions. The third one is the Labor Market Regulatory Authority, LMRA. In LMRA, it deals about it regulates the work permits, labor conditions, and employment disputes. So in employment disputes, we'll see in one company, if I'm saying in my company, we had a recent case regarding some unlawful termination. So in one of our workers in our establishments went to LMRA, and she said, like, I have been terminated in an unlawful way. My benefits were held by the company, and I need a compensation, such things like that. And she went to the labor court and filed a case against us. And we also filed our objection. We submitted all our final arguments, but our arguments were like there was a contract between our company and the worker, so she she did a resignation very prematurely because the contract was there for the 2 years, and soon after the probation period, she gave a resignation letter stating that for such and such reasons, I'll be resigning from the position. So for that, we have incurred so many losses and other things, and we have also filed another case for a premature resignation. And in fact, the labor court was in support of the worker, and we were supposed to pay her compensation and other things. So particularly if you are seeing in this LMRA, the court will look more into the worker's aspects, whether she has been unlawfully terminated or her benefits have been withheld by the company, or her unpaid the leave salary, indemnity, and end-to-end service gratuity has been held by the company. These are the main things that will be looked by a labor court. So coming to the last one, that is NBR, that is National Bureau of Revenue. There, it ensures that the compliance with the VAT law, that is very essential in every of the companies and MNCs and all the business establishments. And it handles the audits, disputes, and enforcement regarding the VAT returns. And coming to the third main point, that is the common areas of corporate litigation. So in corporate litigation, we'll see so many issues with regards to the company. So first one is that we have this disagreements with the shareholder. shareholders of the company, any disputes regarding the shareholders of the company. So first one will be the some misappropriation of the corporate funds, and minority shareholder, some blocking dividend issues, and and other issue is like as I mentioned earlier, that is a breach of contract. So in breach of contract, we'll see one person will before executing, upon signing of the any agreement or any contract, we'll have set up some sort of terms and condition in every of the contracts. You might have seen all the contracts. So when they are ensuring that, okay, I'll be complying with the terms and condition, and thereby if they are violating it, then at that stage there arises a breach of contract. So in companies also we'll see a breach of contracts, whether it reflects to some payment issues or any performance or non-performance, defective performance, which leads to the violation in terms of conditions of the contract. And finally, as I mentioned earlier, the main issues in a company will be the employment litigation. So the labor claims, which means the labor claims, which includes the unlawful termination, unpaid benefits, withholding of relieving certificates, and workers may ask for high compensation if their contract is valid for another 2 years or 5 years, like that. And coming to the yes, and I'll conclude in 2 minutes. So next topic is the risk mitigation strategies. So this is a main important in corporate litigation. As a legal advisor in my company, I always see whether all the compliances have been legally complied, that is a proper term, legally complied with all the sectors. So firstly, for a smooth regulatory compliance, for avoiding any risk, we need to see the regulatory compliance programs we have to conduct, and we need to appoint a compliance officer. Regular training for directors and staff on regulatory changes should be there, and we need to construct a proper, robust contract which includes default clauses, indemnity clauses, all favorable clauses and protective clauses protecting us, and the company director should take the insurance policies. Coming to the final point, that is the role of ADR. As we all know, the alternative dispute resolution plays a main role in corporate litigation. So whenever any disputes arises between two parties or any companies, first they'll go to the traditional courts or to the execution courts. But in execution courts, we'll see it takes a lot of time. But in ADR, we'll get that in a speedy recovery. Even the cost effective is also little more less. So the role of ADR is playing a very important role. So it handles disputes of valued above BD 500,000, that is commercial matters, and business and establishments prefer arbitration for their efficiency. Even courts also supports ADR simply because any cases arises, and rather than going for a longer trials, the court will support the clients, the litigants before the court to go for a mediation talk and to settle the matter once before the trial commences. So that's how, in a conclusion note, compliance and regulatory compliance is a must-have of every company's business establishments and banking sectors. Thank you so much.
Wow. I like it. Thank you, Urmila. Now I will pass it to Betania. She's a great lawyer. She's
How
a nice
brilliant.
speaker.
Like, after all this, I have to go.
We keep the best for the end. So please go ahead.
Last but not least. Well, thank you so
You are
much. I
welcome.
very much appreciate it. Thank you for the organizers for inviting me. I wasn't originally in this panel, so my apologies that I will be reading much of it. But it is such a pleasure for me to be amongst this such amazing and brilliant minds. Colleagues who believe, like me, that the future of law isn't just about litigation after the fact, but about shaping strategies before the problems arise, right? So today's panel, corporate litigation, regulatory compliance, and risk mitigation. As my colleague rightfully said, those three areas are no longer separate conversations, but one of the same. My fellow panelists covered all key points, but I will try to just add a little bit from my experience. I've spent the last decade in the intersection of law, cybersecurity law, especially AI governance, and international regulatory policy. I've been advising companies, government entities, and global organizations like the United Nations, the Organization of American States, the World Economic Forum, the Islamic Development Bank. And my role was how to stay ahead of legal risks in a world that is moving faster than law itself, right? Quite of a challenge. And if there's one thing I can tell you from my experience, whether you're advising a startup, a multinational, or a public sector giant, is this, that compliance today is not just about avoiding fines. It's about survival, resistance, and reputation. And those three things are very important to keep in mind when you're trying to convince the boards of investing in compliance. But that's a different conversation. So we're seeing compliance failures directly trigger multi-jurisdictional litigation, public scandals, executive firings, and even complete collapse of brand trust. I had the opportunity to lead strategic cybersecurity and risk awareness programs in complex environments, including major national initiatives under Saudi Arabia's Vision 2030. I've seen firsthand how embedding compliance into the DNA of an organization not only reduces litigation risks, but also enhances operational excellence and investor confidence. One thing that I always emphasize to my clients now that I work as an independent consultant is that litigation and compliance are converging fast. The companies that treat compliance as a strategic asset, not just as a legal obligation, are the ones that thrive when crisis hit. Regulators, judges, and even the public is asking why you have a strong compliance culture. Where are you proactive or reactive when trying to build this compliance culture? And now the burden of proof isn't just on regulators. You've seen it's shifting into companies themselves, and to show they took the risk mitigation part seriously. And I think that these are the keywords that we've been hearing all along this panel. So let's not underestimate the rise of new risk domains. I'm talking about here AI governance, ESG, which is environmental, social governance, and disclosure risks, cybersecurity, and personal data protection as well. I've been very fortunate to advise on AI and cybersecurity frameworks across different regulatory ecosystems in different parts of the world. And I think that one trend has been quite clear. We think of today as best practices in areas like responsible AI or ethical tech. I think that those are tomorrow's legal standards. Let's not underestimate this. If your compliance program is only looking at current regulations, you're already behind. Let me tell you this. Anticipatory compliance is the new gold standard. Another layer that complicates everything is cross-border risks. We've heard a lot about this yesterday. Different regions, different laws, same data, same product. One data breach today that my colleague right here was talking a lot about contract breaches, but what happens when the information inside that contract is breached, right? It can trigger regulatory investigations in different jurisdictions, Europe, California, Dubai, Bahrain, Singapore, all at once. When I advise multinational clients, a big part of my strategy involves harmonizing compliance frameworks while staying agile enough to pivot when forward to hearing your questions. Exactly. And making up a speech in 5 minutes. This is working now. So it was just a test.
Check.
Hello. Perhaps they can start charging this one. Is it working? This one is working. So you can have this one. And perhaps someone can
Yeah.
charge this one.
It's from our time. Bashayer, be ready, please.
Yes.
As a Bahraini lawyer.
Yeah.
Okay, so I'm asking you something about Bahrain regulations and like this. And how does Bahrain's regulatory framework compare to international standards?
Regulatory framework.
Yeah. So can you give us some explanation about this?
Yes, I believe Bahrain has made strong strides to align with the regulatory framework. International best practices, particularly in the financial services, data protection, and corporate governance law, such as the data protection law and CBB regulations, for example.
Okay.
Long answer?
No, it's enough for me. I don't know, it's enough for you? Perfect? Did she? Okay. I will pass to Mr. Mousa. I would like to ask you about something you're experiencing. I want a real chair. Can you real world example where early compliance action helped our organization avoid potential litigation? Give us an example.
Thank you for the question.
You're welcome.
Before going to answer the question, I saw that all of us use one term called risk mitigation. And I want to add just one spot of area for where we are talking about risk mitigation, because there is a process for it. So risk mitigation we can go for accepting the risk, or rejecting the risk, or transferring the risk, or moderating, reducing the risk. And where we can accept comes from companies who are really establishing a risk appetite. So if you have your risk appetite identified, the people on the ground will understand that this risk can be accepted, this risk can be minimized, this risk can be transferred or rejected. But also, before the risk appetite, there is a big exercise that companies need to do more effort, which is risk capacity. There is some area that companies are not really on the ground doing their analysis to have risk capacity. My risk capacity is different, so when it comes to ethic, there is no compromise. When it comes to financial risk, to grow as a company, of course you need a risk, but what kind of risk, how much risk, where this risk will come from and how it will impact me, is an area that you have to highlight. So the risk that will come from the four areas where people, system, and policy and external factor will help me to identify my capacity, and my capacity will help me to write my risk appetite, and my risk appetite will help the people on ground to have this risk mitigation that will have four options, either to accept, reject, or transfer, or reduce. So the life example I have, I remember when I was in Mondelez Craft Food, they were outside of KSA, and the distributor was Al-Ulayan. So I joined the company even before they have commercial registration, the Mondelez. And you have a local company who's following the regulation of KSA, and U.S. company who has under different regulation, and we have to follow strict KYC, strict AML, and some other standard regulations that we have to embed it on the area. So this is one regulation risk that we have worked closely during the transition, and this helped us to strategically avoid the risk that might come from just ordinary transfer. So writing the policies and the procedures and the contracts and the guideline and establishing this governance helped us to have this risk avoidance. We want to invest more, and companies should invest more risk avoidance by involving you as an expert or other, where the cost of involving consultant is less more than going at the end of the stage where you will pay even maybe a collapse or getting out of the business when you don't pay the small amount of establishing the right governance inside your company. Sorry for taking more time.
No, thank you. Nice. Urmila, please, be with me. You are a corporate lawyer.
Yeah, yes.
Okay. In Bahrain, here, how do companies typically navigate the intersection of corporate litigation and compliance issues, especially when they involve conflicting regulations or unclear legal boundaries? Give us an...
So basically in Bahrain, the companies must follow the local laws, I mean the local rules and regulation, in order to avoid any future litigation. So main thing is that a proper compliance program will help in ensuring that all the compliances have been done in a proper way, and thereby we can mitigate the risk in all over the companies.
Thank you. Betania, simple question, please.
Yeah, sure.
Because you are talking about cultural factors, right? Yeah. So I want to... What cultural factors inside company help to ensure compliance framework succeed and reduce legal risks? Give us a brief about this. You understand the question?
Yeah.
Okay, thank you.
Yes, thank you very much.
You're welcome.
I'm so happy to have a microphone now. So when we're talking about culture, I like to talk about the culture across the whole company. This comes from the top up, the top down, sorry, from how the C-suite treats their employees and senior management, and how senior management treats the people below and such. And when you put corporate compliance as a priority, as part and embedded in the culture of your company, and make sure that across the organization, it is second nature for all the departments to consult. Well, my point is trying not to work in silos. That's not something that we can afford to do anymore. Legal teams, compliance teams, even in my case, what I've seen in cybersecurity teams, they have compliance teams who work together with the corporate compliance teams, the legal teams. And why is this? It's because we need to have an homogeneous corporate culture in how we are going to not only frame our compliance strategy, but also how we're going to react when something bad happens. Because again, as I said, it will. But we have to be ready for it. We have to have a proactive approach instead of a reactive approach. And I think that comes with the company culture.
Wow, thank you. I am running out of time. I have many questions, but if you want to ask some questions, please, yes, it's your time. Give the mic, please.
Thank you very much to all the panelists. It was very enlightening. I would like to revisit quickly something that Betania touched upon, and a question that Mr. Mohamed raised to Urmila about conflicting compliance requirements. Now, my question is that as legal professionals, what can we do to not just fill compliance gaps, but to design better strategies that I'm sure Betania already does, when there are conflicting compliance requirements? I'll give you an example. For example, according to CBB, there's a requirement of local data storage, that what is here stays here, basically. But under European law, GDPR, they have to transfer. They are asked, the requirement is that you have to transfer the data if it's a European citizen or a resident. So I mean, the conflict is there. So when there are conflicting, and there are other laws as well, where the countries have conflicting laws, as a legal professional, how do you reconcile that? What strategy would you adopt? Because we talk about that we should have good strategies, but what really would you recommend in such a situation where the country's laws are conflicting? Thank you.
Thank you so much. This is a great question, and it brings me to something that has been mentioned a lot yesterday, which is conflict of laws. And when we have to make a choice of law in terms of where we're going to be taking this in case things go wrong. But when we have technology in place, it happens what you're saying. We can have something that, for example, a cyber attack happens in country A that was planned in country B with data storage in country C, and that it affects country D, you know? What happened yesterday in Europe still is under investigation, but they're not dismissing the possibility of a cyber attack. And so in a world that is so interconnected, cross-border regulation, it is extremely important. So what we try to do in face of these challenges is to try to be as comprehensive as possible. First of all, to try to be smart in the choice of law. And second, to have a global approach, and I think that humbly, that's kind of the difference that I bring, having lived and worked in different countries, is that when you are advising a company or an organization here in let's say Bahrain or in Saudi Arabia or you name it, is to understand that there are other regulations in place in other places. What you mentioned, GDPR. Most PDPLs look up to GDPR, and they try to accommodate it to their own complexities locally, because naturally every country has its own and unique challenges. So sometimes a best practice that is not required in your own jurisdiction could be great for your operational efficiency. And that is what a global approach means. So that's how you try to solve, in a way, the differences that you have in your own jurisdiction and what your regulation asks you to do mandatory to comply and to avoid fines, etc. But also you have to keep in mind operational efficiency. So I think that to wrap up, the choice of law is one point, cross-border regulation, and to have a global approach when we look into compliance challenges, to try to not only avoid possible problems, but when we have them, to have the tools to get out of them the best way possible.
Thank you, Betania. No, you answer. No, don't hope. You answered already. Thank you. It's okay? Really? Okay, thank you. Any other questions, please? Yes, was here.
Hi, good morning. One of the things that perhaps intrigues me is there are laws which are not enacted in this part of the world. So, for example, you guys mentioned GDPR, which have, of course, extraterritorial jurisdiction. How do you manage that kind of risk when advising clients? And what is the most kind of critical obligation that you can think of when something similar crosses your path?
Okay, thank you. Mr. Mousa, you can answer. What? I didn't get there. Can you repeat the question, please? I'm so sorry. Okay. Okay, Urmila.
So the question is about typically GDPR, but perhaps more about laws which have extraterritorial application. And how would you go about advising clients and managing risks in terms of the outstretch or the reach of the laws in countries in this part of the world, which of course are not EU member states?
Thank you very much for the question. Yeah, I think it builds up from my previous answer. To understand, so GDPR is like the mother of the PDPLs. So I think that even when you are working with a specific local regulation, it is important to have the GDPR in mind and understand, especially because most likely your business will have some sort of repercussion in the European Union and will be affected by GDPR. So my suggestion is to always try more than less. Again, as I said before, sometimes your jurisdiction will ask you to comply with ABC, but I would always advise to go the extra mile for not only compliance purposes, because your business will most likely grow and you want to be prepared for that. Do we really want to go back and review the strategy or the compliance framework all over again every time you make a new deal? Not really. So we try to be as comprehensive as possible. So that is my suggestion. And also, when we see what we see now with the EU AI law and how other jurisdictions are also developing their own regulations on artificial intelligence, which is like extremely cross-border. How do we look at this? It is advancing at a pace that is very difficult to regulate, not only because it's difficult to arrive to a consensus, but also we don't have enough skilled players in this different disciplines that we need in order to frame not only internal strategies, but also policies and laws, regulations that have the languages that will allow this documents to survive the rapid evolving pace of technology.
Okay, thank you.
I hope it answers the question.
Yes, it
well,
is.
we can definitely talk more in the coffee break.
Yeah, but because I run off, the time is run out. Okay, unfortunately, time is out, and I want to stay all the day with these experts. They have rich informations, but what can I do? Please greet them, and thank you all.
Thank you. Now I request the moderator to honour the panellists.